Yeah.
All right, this is case number 20154743. This is HS Financial Group versus Marilyn Lawson. Matters before the court on an application for subpoena. Your appearance regarding this matter for HS Financial, please.
Good morning, Your Honor. My name is Michael Conway. I'm appearing on behalf of HLS Financial. Your Honor, a subpoena was served upon the defendant in this case. Today is the date and time set for a creditor's exam, and it was scheduled for 9:30 this morning. I don't believe the defendant has appeared. I would ask the court to issue either a bench warrant or show cause.
Thank you, counsel. The court is looking now for Marilyn Lawson, a person living on Montrose Street in the city of Detroit. If you are on this Zoom, please say something at this time. It does appear that the defendant has failed to appear with regard to the subpoena in this matter. Inasmuch as that is the case, the court will issue an order for the defendant to show cause. The show cause date in this matter be set for just one moment, counsel. Yeah, just beyond.
September 26th.
Right.
September 26th.
September 26th, counsel, if you'll present a proper order, the court will sign off on it and get that right back to you. You can email it. So if you're ready, I'll give you an email address where you can get that in to me, and we'll sign it and it'll be set for that date. Again, that date is September the 26th at 9:30, 9/26, 9:30. The email address is Latifah, LATIFAH @3636th at 36districtcourt.org.
Thank you, Your Honor. Appreciate your courtesy.
And his P number, Judge? Could I get his P number?
Sorry, counsel.
My P number is 12165.
Thank you.
All right, thank you, counsel. Good day to you, sir.
Thank you.
The court now calls case number 21-156-804. This is SMSE Federal Credit Union versus Alfonso McKay Jr. Matters before the court on an application for subpoena. The court did sign and issue a subpoena previously regarding this matter. Your appearance for SMSE Federal Credit Union, please.
Yes, Your Honor. Ronald Scherf, CHERF P 23315, appearing on behalf of the credit union, Your Honor.
Thank you, Mr. Sheriff. I'm looking now for Alfonso McKay Jr. If you're on the Zoom somewhere, please say something at this time. Again, looking for Mr. Alfonso McKay, a person purportedly living on Cortlandt Street in the city of Detroit. Please say something if you're on the Zoom. It appears that while this matter is set on at 9:30, it appears that the defendant in this matter has not appeared. Counsel, your pleasure at this time, sir.
Yes, Your Honor. It's my understanding from the prior matter, you go to show causes on these matters. So I would ask that the court issue an order to show cause on this.
The court will issue the order of show cause as requested in this matter, and we'll set the show cause on for the 26th of September, 9:30 a.m. September 26th, 9:30 a.m. And counsel, did you get the email address where you can send your proposed order of show cause, sir?
No, I wasn't able to write it down as quickly as Mr. Conway was.
Not a problem. That's going to be Latifah, LATIFAH dot, last name is Hunter. That's at 36districtcourt.org.
District court's all spelled out.
Yes, sir.
Okay. Latifah, LATIFAH .Hunter at 36districtcourt.org.
That's correct. You got that 36th, correct?
No, I didn't. 36. Okay. Thank you, Your Honor.
And you're all set. All right. Thank you. Good day to you, sir.
Thank you.
The court now calls case number 21-168814. This is Garden View Homes 1 LBHA LLC versus Chanel Grant. The matter is before the court, set on for a hearing on a motion for summary disposition. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff.
All right, thank you, Ms. Baker. Good morning to you. I'm looking now for Ms. Chanel Grant. If you're on the Zoom, say something at this time, please.
Chanel Grant.
All right, good morning to you, Ms. Grant. I have received the motion, and counsel, I'm going to allow you to go ahead and give me, ma'am, let me ask you, Ms. Grant, did you file a written response to the motion at all?
I filed the written response with everything, the interrogatories and the things that were sent to me. I did send those back with a signature, as they said.
Of course, you didn't answer the question that I asked you, though, but I'll ask it again. The motion for summary disposition that was filed, did you file an answer to the motion?
I'm assuming I did with all the paperwork that I did. So I'm gonna say yes, because I believe I did.
Yeah, because I don't believe I see anything in the file that shows that there's an answer to that document, to that motion. Madam Counsel, did you receive an answer from the defendant regarding the motion?
No, Your Honor, and we were here on July 7th for the motion for summary disposition. And at that time, the court did adjourn the matter to today to allow a defendant to file a proper answer to our motion. And we have not received that.
Yeah, that's what I was talking about, Ms. Grant. It's not a trick question or anything. It's just an inquiry as to I adjourned the matter to give you an opportunity to respond to the motion for summary disposition. My question was whether or not you had done so, because I didn't see anything that was indicated as an answer to the motion. All right. You may at this time, Ms. Baker, proceed by way of your motion, Madam Counsel.
Thank you, Your Honor. This is plaintiff's motion for summary disposition regarding non-payment of rent. Attached to our motion is a signed lease agreement from the defendant, as well as a statement of account enumerating the damages of 2129. Again, it's our position that the defendant has not filed a response to this motion under 2.116G, and that we're asking that our motion be granted.
All right, and the reason now, or your purpose in bringing forth this motion is you're arguing in the motion that defendant has failed to state a valid defense to the claim that has been brought pursuant to MCR 2.116C9. Therefore, you would ask the court grant judgment. You've also have indicated that there appears to be no genuine issue of material fact, and you're asking alternatively that the court will grant the motion under MCR 2.116C10. Is that correct, counsel?
That is correct, Your Honor.
Right now, I know that there has not been a response to the motion, but I also know that the defendant did file an answer in relationship to this matter. And I know in the answer, the defendant points out that the security deposit was retained. And that no account billing statement was received. Those were some of the items that she pointed out in the answer that she filed with the court. All right, so let me ask just one moment. And the defendant also answered that she was locked out of paying defendant online as a part of her answer. All right, now, Ms. Grant, tell me why you believe that the motion for summary disposition should not be granted at this point now.
It's the amount. I don't know what the summary motion for disposition is. I don't even know what that sheet is. I looked through the papers and I didn't see that summary motion for with questions on it. But nevertheless, it's the amount that I'm arguing. It's too high. Is they're arguing for more than what's actually should be collected. I went in the last hearing, we even came up with the number of amount and we went into a breakout room and they refused that amount.
All right. All right, so first of all, yeah, the first thing that you helped to clarify by your position regarding this motion is that this is a dispute regarding the dollar amount and not as to the claim that has been set forth. Accordingly, the court will grant the motion for summary disposition, finding that there is no genuine material issue of fact except as to damage amount or as to the amount that is owed regarding this matter. So the motion is granted in that regard. Now, the claim in this matter asserts that there are damages in excess of $2,100 and that there is, of course, court costs and a statutory attorney fee that might apply regarding this matter. So what of that $2,100 do you believe, Ms. Grant, is not a part of your obligation in this matter?
After the last court case, the amount was $1,622.50. It was the court case, the fees for the court case. I believe you had broke down into half. It was an amount of $162.50 and $150. And then somehow you came up with $302.50 with the amount for the fees of rent being $1320 for a total of $1,622.50. I agree.
I think, I don't remember this case in particular, but I think that the court may have been involved in trying to find a way for the parties to reach a settlement. Is that what you're talking about? All right,
Correct.
so in order for there to be a settlement, both sides has to agree on that number. So in trying to help the parties come together, I made suggestions as to what the numbered amount should be, but the parties could not agree on that. So that's, I can't force the respective parties to agree regarding the dollar amount. Let me ask you, Ms. Baker, what is your client claiming as a total amount due with costs and any statutory attorney fee, et cetera, at this time?
The total amount we're claiming due is $2,388.47. The security deposit was applied. Our motion for summary disposition did include an itemization of the unpaid rent, the late fees and the legal fees, and the application of the security deposit.
All right. And so if you take out the, for purposes of the looking at the numbers, if you were to take out the court costs, et cetera, you're still in this matter roughly at $2,100 or so. Is that correct?
That is correct. $2,129 without the court costs and statutory attorney fee.
All right. So that the $2,129, counsel, you're indicating that is for past due rental obligations and fees that would have accrued while those obligations were not paid, correct?
That is correct, Your Honor. And again, we did attach an itemization of those fees and unpaid rent.
All right, and I do see where there is a document indicating an itemization. All right, so how much was the rent on a monthly basis, Ms. Grant?
$440.
$440. And so, counsel, it looks like at the time that the defendant left the property, there's a claim that there was unpaid rent of $2,428, and that the security deposit was subtracted from that amount. But then there were also the accumulation of legal fees at $316 and late fees at $140. And so after adding those, the number you came up, that's how you got to the 2129 figure. Is that correct?
That is correct, Your Honor.
All right, Ms. Grant, the document says that there was unpaid rent from March through June of 2018. That's when this case arose. Is that correct, ma'am?
No, sir. I paid rent from March to May 31st, 2018. Vacated the property on on May 31st, 2018, per the courts, per my U-Haul, per Section 8, where I have to put in notice to vacate.
All right, and so you have receipts showing that you paid rent for April and May.
No, I didn't pay rent for April and May. I agree that I did not pay for April and May.
All right,
The
so,
March rent
you're
is
saying-
also due, Your Honor.
Well, that's why I'm making my inquiry. All right, so you're saying that you paid for the month of March.
No, the month, March, April, and May, I did not pay. I was locked out of the portal through March through April.
Okay. And, all right, well, I don't see what the dispute is because they're saying that you didn't pay rent during that period of time and that it would have applied to June as well. Those are the months that they're saying that you didn't pay rent.
How is June included when they receive per Section 8? Because you can't leave with and still keep your Section 8 without an intent to vacate. So it was known that I was out by the 31st. How am I charged for the following month?
All right, did you give notice of your written notice of your moving from the property,
Correct.
Madam Counsel?
Your Honor, I don't believe there was proper written notice under the lease. Paragraph 17 on page 9 of the lease allows my client to add the additional monthly installment for rent for June if proper written notice is not given under the lease.
Well, what do they mean by proper written notice? What notice did you give them?
You were talking to me. I gave them the one from Section 8 where it gives you an intent to vacate.
All right. All right, well, I think that on that issue of damages, that is a reasonable issue that has been asserted by the defendant in regard to this matter. And it's not altogether clear to this court that the plaintiff is entitled to rent for that month. Accordingly, I will strike the rent for the month of June, and judgment will enter on the terms as previously prayed, except for the rent for the month of June and any late fee that would have applied to the month of June. The order may enter accordingly, and I will sign the order upon presentation to the court under the grant of the motion for summary disposition. That is my order.
Your Honor, could we then just to clarify, you're striking the $773 for June and the late fee of $35. And then we can,
My understanding is that the rent is $450. Is that correct?
$440.
Your Honor, the lease, the rent is $773. She was under a special agreement. I believe she was getting some help from the Department of Housing. So she was charged just the $440 for March and April, but the full rent charges were implemented for May and June.
Well, yeah, you'd have to strike the June rent. I thought it was at $450, so you would strike that the June rent at whatever rate was assessed, and the judgment would enter accordingly. Otherwise,
The May rent was assessed for the full amount as well.
the May rent may be included.
Okay. So judgment for March, April, and May, just to clarify for the court and for our order, if I may get this calculated quickly, $440 for March and April, $773 for May, puts us at $1,653. And then $35 late fee times 3 is $105. And then the legal fees of $316. $2,074 plus court costs and attorney fee.
I think that what you need to do is go through your calculations, the way that you get it on the charges. And subtract the security deposit from your overall amount. So that whatever you conclude, you gotta subtract the security deposit. And then go forward in that way. So basically your top number on the, your top number was at 24.28 on the unpaid rent. So that 24.28 would be reduced by the rental amount for June. And then you would add in the numbers that you indicated, subtract the security deposit, and then you go from there.
Okay, since this was just not a trial on the damages, Your Honor, I think since my client is seeking the full balance, that we would just request a summary judgment as to liability and then set this for trial on the damages.
So what you're saying to me is where the defendant is operating under Section 8, and she's given some type of notification regarding Section 8, that what you and your client want to do is to have this court to try this case about $700 and some dollars. Well, okay, I'll set it up for trial. There will certainly be an assessment of costs and sanctions if there's any indication that there's been proper notice. And I'm not trying to give anybody a hard time, but my goodness, this it seems to me. Well, I won't tell you what seems to me. Let's just go ahead and set it up for trial. Give me a trial date for.
Your Honor, may I ask if I could just have this case passed so I can consult with my managing partner and then come back?
Yeah.
And I think we could resolve it then.
Yeah, let's go ahead and do that. And maybe maybe there's an insufficient notice. I don't know. Maybe you're right about a trial. Maybe you want to discuss between the parties a way to resolve that issue. I just think that at this point, there's not really a dispute over most of this. Again, when a person leaves a property, these are some of the issues that get involved. Sometimes it's not just 1 month, sometimes it's 2 or 3 months that this type of thing accrues. So it seems to me that where this 1 month was involved, that maybe this is something that should have been resolved some time ago. I don't know. See what you can do with it. And then when you come back, perhaps you and Ms. Grant can talk in a breakout room. Most of the cases resolved based upon the court's order, and if you get the rest of it resolved, then so be it. All right.
Okay.
All right. So I'll come back to you. Just stand down, Ms. Grant, for a moment, and we'll come back to you, matter short.
I appreciate the time, Your Honor. Thank you so much.
All right, thank you, counsel.
Mhm.
All right, the court now calls case number 21-173-498. This is Michael Eldrick versus Jalen Brown. The matter is before the court, set on for a hearing. Looks like a first hearing, I believe, where I've received an answer to the complaint. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Attorney Jessica Warfield, P85391 on behalf of the plaintiffs.
All right, thank you, Ms. Warfield. Good morning to you, Madam Counsel. Do I have Jalen Kevon Brown on the Zoom? If you're on the Zoom, please say something at this time.
Yes, Jalen Kevon Brown.
All right, thank you, Mr. Brown, and good morning to you as well, sir. Madam Counsel, update me. It looks like you're at the beginning stages, or were there some discussions on this? Talk to me.
Yes, so just to bring to the court's recollection, we originally did pursue action against both Mr. Brown and his mother, Miss Tina Miles, because his mother was the last known person to have the insurance on the vehicle in question. After speaking with Mr. Brown today, we believe that we have come to a resolution. Mr. Brown has agreed to the damages amount. We would like to speak with our client about possibly dismissing Miss Miles from the matter, and we would be entering 2 consent judgments to the court regarding the damages based off the conversation we had with Mr. Brown today. So we would actually ask the court if we could set this matter for a pretrial date, just to give us time to do that and make sure the court has all the necessary documentation.
Mr. Brown, that makes sense to you, sir?
Yes, sir.
All right. All right. So let me go ahead and set it over a few weeks right after I'm back, I suppose. Maybe squeeze it in somewhere. It's probably
The 19th,
September
19th, yes.
September 19th. I'm going to set this at 10 o'clock a.m. September 19th, 10 o'clock a.m. I'll set the matter over for pretrial and review. Pretrial and review, September 19th, 10 o'clock a.m.
Thank you so much, Your Honor.
Thank you. Good day to you, Mr. Brown.
All right, good day to you too.
And we're on the record now regarding case number 01-133-938. This is Botsford General Hospital versus Alphonse Carrel. The matter is before the court on a motion to set aside a default. The record should reflect, based upon the register of action in this matter, that a judgment was entered by default in this matter initially. That was the 18th of June, 2002. It looks like the judgment was renewed in this matter on 2012. That would be May the 23rd of 2012. And it looks like there was a second renewal of the judgment in December. That is December 22nd, 2021. Your appearance for the plaintiff in this matter, please.
Yes, Your Honor. Susan Winters appearing on behalf of the plaintiff. My P number is 41153.
All right, thank you, Ms. Winters, and good morning to you.
Good morning, Judge
For
Coleman.
For the defendant in this matter, your appearance at this time.
Yes, good morning. Lawrence Lucido, for the defendant, seated at on my left. My P number is P58759.
All right, thank you, Mr. Lucido, and good morning to you as well, sir. This is a rather attenuated, if you will, motion. It seems that the judgment was entered by default and then renewed 2 times, and a judgment that's like 20 years old. Talk to me, counsel.
Your
Yes.
Honor, we do have a resolution to the case that we can place on the record. Mr. Carrel is there with Attorney Lawrence Lucido. We've discussed this case back and forth over a period of time, and we have resolved to settle it for a payment of $1,457.99 payable over the next 3 months in 3 almost equal installment payments, although the first one will be $457.99 by the end of August, $500 by the end of September, and $500 payable by the end of October. And Mr. Lucido, I had indicated, I just replied to your email. I'm sorry, I didn't see it yesterday. We are agreeable with a 7-day grace period if that works.
That is perfect, and thank you very much.
All right, all right. Sounds like there's a resolution, Mr. Carrel. Is this resolution suitable to what you wish to achieve in regard to this matter, sir?
I agree with the situation, Your Honor.
All right. Well, I was expecting a 20-year argument. I was.
Can I say something? I was going to do that because I mean I was going to do that, but my wife talked about it.
The lawyers know I was being a bit facetious about that.
All right.
My client's happy.
I'm good. I'm happy with it.
Mr. Lucido and I already had that 20-year argument off the record, Your Honor.
Very well, very well. All right, the court will consider the matter resolved, and I will await the presentation of your order regarding this matter. I gave out an email address where you could effectuate that. Did you take that down or what?
I have Ms. Hunter. I didn't get the spelling of her first name though. It's
Latifah, Latifah.Hunter. That's at 36360districtcourt.org.
All right, great. I will share that with Mr. Lucido. And is that all that we need to say, Mr. Lucido, or did you have anything else to add?
No, I believe that's it. I think we got everything covered. My client, I believe
Yep,
my client.
everything's good.
So
All right.
just let me know how where to forward the payments and in what manner, I think we'll be fine. I believe you even have a facility to make the payments online. Is that correct?
Yes, we do.
That's great. Okay.
Well, I trust that the fact that you worked through 20 years of this, that you'll be able to figure that part out.
All right, Judge Coleman, it's so good to see you. I haven't seen you in so long. Take care.
It's been a long time. And I was looking at Mr. Lucido as well, and, 30 years ago, I interacted with the Lucidos a lot. I had an office in Macomb County and one in the prosecutor's office there. So it's just the years have gotten by. But give my regards to everyone, to all of this Lucidos. I don't remember everybody.
Of course.
And, it's certainly a pleasure to see you as well.
Of course.
Good to see you. Take care. Enjoy the rest of your summer, everyone. Take care.
All right.
Thank you. Have a good one.
Bye-bye.
All right, Ms. Baker, I see that you're back, ma'am, and welcome back on this matter. I see that Ms. Grant is here as well. Just trying to find a way to a conclusion here, and I think we spent a little time on this this morning, so we're trying to figure out how to get to a conclusion here. Ms. Grant, you may.
Thank you, Your Honor, for allowing me an opportunity to discuss this and make sure we could agree to this. And the court's ruling was that we could have a judgment for the March, April, and May rents, which would total $1,653, the late fees of $105, the legal fees of $316 minus the security deposit. That brings our damages to $1,321, and then court costs of $184.47 and the statutory attorney fee of $75.
That would be correct.
And that is
would be-
acceptable. That is acceptable to the plaintiff.
All right, the court will sign the order upon its presentment to the court.
And may I submit that via email as well, Your Honor?
Yes, you may. Did you take that information down?
Yes, I did.
All right. Very well. I will sign the order upon its presentment. Thank you, counsel.
Thank you so
Ms.
much.
Grant. Good day to you as well, ma'am.
Thank you.
Mr. Alkins, why are you here, sir? And I don't have a file, so.
I think I believe you're correct, Your Honor. Unfortunately, my main office computer suffered the death of a motherboard going and taking up my entire electronic calendar, except for some odd entries. This ended up being an entry. I didn't want to offend the court by not being here. I didn't think we had anything, but it was on my calendar. So I apologize for any inconvenience.
Oh, no, not a problem at all. But I can confirm that there's not anything on the court schedule regarding this matter.
Thank you, Your Honor. It was a pleasure to see you.
We'll see you soon, sir.
Thank you.
Okay.
All right. That was the